Welcome back to the deep dive. Today, we are getting to grips with a topic that is, I think it's fair to say, one of the most ethically challenging and high-yield areas for any junior doctor.
Oh, absolutely.
We're talking about consent for children and young people, and this isn't just about medicine. It's about navigating this really complex legal landscape that defines a young person's autonomy.
It really is.
Okay, so let's unpack this. We've pulled together the crucial GMC guidance, some key legal rulings on Gillick Competence and the Fraser guidelines, and, the patterns we see coming up again and again in the MSRA SJT.
Mm-hmm.
Our mission today is to take these complicated, sometimes contradictory rules and sort of forge them into clear, structured decisions so you can act ethically and legally every single time.
And that's the key, isn't it? Because this topic is routinely rated as moderate to hard for a reason.
Yeah.
The balance is just so delicate. The core tension, both in the clinic and in the exam, is figuring out how far you support a young person's right to choose their autonomy, while also fulfilling your safeguarding duties and involving parents when you should.
And if you get that wrong?
Well, if you approach it without a solid structure, you risk making an error that could compromise a patient's safety or, even breach their rights.
So let's jump straight in with that tension. Imagine this dilemma, and you will face this either in an exam or in real life. A 15-year-old patient comes to you, asks for contraception, and is very clear they refuse to involve their parents.
The classic scenario.
Exactly. What is your immediate, ethically and legally sound first step? The path you choose right there. That's what separates a high-scoring compliant action from a really risky one.
That scenario just perfectly highlights the core truth of this whole thing. I mean, if we had to boil it all down to one sentence, it would be this. Consent for under 18s hinges on 4 essential factors, in order: age, competence or capacity, parental responsibility, or PR, and best interests. You have to check those 4 boxes, and you have to do it in that sequence.
And that's straight from the GMC guidance, isn't it?
It is. The guidance for doctors dealing with patients from 0 to 18 is explicit. They expect you to be fluent in assessing capacity in minors, involving families when you need to, and knowing exactly how to handle these really sensitive issues.
Which is why that sequencing matters so much for the exam. You can't just let your gut instinct for, say, paternalism or total secrecy win. The best answers always follow that strict legal pathway.
Age, competence, PR, best interests.
If you miss that assessment of their actual ability to understand the decision, the rest of your process is just built on sand.
So we really need to anchor this on the specific legal thresholds. We've basically got 2 big divisions here, under 16s and then 16 to 17-year-olds.
Okay, let's start with the under 16s. We always hear the term Gillick competence. For anyone listening, how is that different from, say, adult mental capacity?
That is a crucial distinction.
Mm-hmm.
For an adult, we use the Mental Capacity Act, the MCA, which presumes capacity unless you can prove otherwise.
Right.
Gillick competence is different. It's not about global capacity. It's about whether the young person has enough understanding and maturity for the specific decision you're talking about right now.
So it's not like a switch that flips on their birthday.
Not at all. It's evolutionary. A 14-year-old might be Gillick competent to consent to a simple vaccination, but maybe not for a really complex surgery with, lifelong consequences.
Okay, that makes sense. It's decision-specific and developmental.
So what of the 16 and 17-year-olds?
The rules are much clearer here, and this is a vital piece of law to remember. The Family Law Reform Act, 1969, Section 8.
Right.
It says that anyone aged 16 or 17 is presumed to be able to consent to treatment as if they were an adult. Their consent carries adult weight. That presumption is a cornerstone of respecting their autonomy.
That's a huge shift in legal standing.
Yeah.
So if a 16-year-old consents, that's pretty much the end of the legal conversation.
In most cases, yes. But let's rewind a second. Back to the under 16s. If you assess them and find they are not Gillick competent for that decision, where does the legal responsibility go?
Then you have to turn to someone with parental responsibility, or PR, for consent. But, and this is critical, the duty to act in the young person's best interests is still paramount.
So a parent can't just consent to anything.
No. A parent can never consent to something that isn't in the child's best interests. Their consent gives you the legal authority, but your duty as a doctor guides the ethical direction.
And this structure is exactly what the examiners want to see. So for the SJT, we need a clear, reliable framework. Forget the long lists for a moment. If I'm in the clinic, what's the very first non-negotiable step?
You have to establish the legal frame. We can call it the age and urgency step. So step 1, Establish age, urgency, and PR.
Is the situation life-threatening? Are they 15 or 16? Who actually has parental responsibility?
Exactly. That's the whole stage.
Okay, so if the situation isn't urgent and the person is under 16, then the next critical step has to be assessing their autonomy.
Absolutely. Step 2. Assess Gillick competence or capacity. You have to find out if they truly understand the consequences, the benefits, the risks, the alternatives of the decision they're trying to make.
And going back to our first scenario, the 15-year-old asking for contraception, if they pass step 2, they're Gillick competent, but it's a sensitive area. So that brings us to a specific legal test, right?
It does. Step 3. Apply the Fraser criteria. If the decision is specifically about contraception, sexual health, or termination for an under 16, you have to apply these criteria. It's the lawful way to provide that care without parental knowledge if the young person is competent.
And once we've done all that established competence, applied the legal tests, what's the mandatory ethical step before you do anything?
Step 4. Explain confidentiality limits and encourage parents. You have to explain that you respect their privacy, but confidentiality is not absolute if their safety is at significant risk.
And you have to encourage them to involve their parents.
Strongly encourage them. Even if they're competent, you have to encourage them to talk to a trusted adult.
That transparency is so important. You never promise something you can't uphold.
Precisely. And finally, step 5. Document everything. Your findings, your assessment of competence, the rationale for your decision, any safeguarding plan. Traceability is your professional defense.
Okay, so that's the 5-step process. To make sure that sticks under exam pressure, we've put together a mnemonic, age safe.
Age safe covers that whole legal pathway. A is for age and urgency.
G is Gillick test.
E is for explain Fraser or PR needs. S is for safeguard and confidentiality limits.
A is agree, plan, and owners.
F is for follow-up. And the final E is for enter notes. Use age safe to bring some order to the chaos.
And let's just drill down a bit on that step 3, because the contraception scenario needs the Fraser 5 criteria. What are those 5 checks?
Right. They have to meet all 5. 1, they understand the advice. 2, they've said they won't involve their parents. 3, they're likely to continue sexual activity anyway. 4, their physical or mental health is likely to suffer without the care. And 5, it's in their overall best interest to treat them, which includes offering things like STI testing.
And if they fail just one of those?
You cannot proceed without parental consent or, in some cases, a court order.
I find a visual cue helpful here. I kind of imagine 2 overlapping circles. One is young person, the other is parents SPR. And there's a little legal scale icon labeled best interests, bridging them.
That's a great image.
It just captures that conflict you're trying to manage, doesn't it? Bridging that gap between autonomy and protection while always tilting the scales towards the best clinical outcome.
Speaking of protection,
Yeah.
we absolutely have to talk about the red flags, the scenarios where your duty to act immediately just completely overrides confidentiality.
Okay, so what are the non-negotiable immediate intervention points?
First, risk of significant harm or abuse. If you think sharing information is necessary to prevent significant harm to the child or someone else, you share it, even without consent, and you document why.
Right. What's number 2?
Second, refusal of potentially life-saving care. If a young person is refusing treatment that's critical to their survival, you have to get urgent senior and legal advice immediately.
And the third one?
And third, disclosure of under 13 sexual activity is always, automatically, an immediate safeguarding referral.
Regardless of how mature they seem.
Regardless of anything, the age itself triggers the mandatory referral.
Significant harm, life-saving refusal, or under 13 sexual activity. Those are your hard boundaries. Okay, let's see how this all applies to the common SJT scenario patterns.
Pattern 1 is the contraception request, our 15-year-old scenario. What's being tested is your ability to sequence the actions. You assess Gillick competence before you apply Fraser criteria.
And you encourage parental involvement without making it a condition of treatment.
Exactly. The trap is to either refuse care out of fear or to jump straight to telling the parents. The best action, provided Fraser is met, is to provide the care and document that strict process you followed.
Because refusing care if they meet the criteria is a low score. It undermines their rights and puts their health at risk.
Precisely.
Okay, pattern 2, refusal of high-stakes treatment. The 16 or 17-year-old case. This tests your respect for that FLRA Section 8 presumption of adult consent.
It does. So if a 17-year-old is refusing, say, a kidney transplant, what do you do?
Well, you have to treat the refusal as valid first. Right. explore their reasons, confirm they still have capacity for this huge decision, and get a senior colleague involved.
Yes, but here's the critical complexity. Even though their refusal carries adult weight, if it persists and the risk to life is grave, you must seek urgent legal advice.
Why is that? I mean, if they're presumed to have adult capacity, shouldn't their autonomous refusal be final?
This is where the tension gets really profound and why it's a high-scoring scenario. Unlike for adults, where the MCA gives an absolute right to refuse treatment if you have capacity.
Okay.
For 16 and 17-year-olds, the courts still have this residual power to override their competent refusal if it's deemed overwhelmingly in their best interests.
So the highest score comes from respecting the refusal initially, but then recognizing that there's this legal pathway to override it that just doesn't exist for a 40-year-old. You have to escalate.
Precisely. That escalation shows legal diligence.
Yeah.
The traps here are letting parents override the refusal or failing to escalate to legal counsel.
Right. And pattern 3, confidentiality versus safeguarding. This is about proportionate sharing. How do we approach that?
The first step is always setting the boundary early and clearly. Use phrases like, "I will keep what you tell me private unless I become concerned that you or someone else is at risk of significant harm."
Manages expectation.
Exactly. You only share without consent if that significant harm threshold is met, and you document your rationale robustly.
Let's focus on detecting those common score killers, the answers that look easy but just show a fundamental misunderstanding of the law.
Step 1. The parent must always consent. This is a fatal error. It completely ignores Gillick Competence and the Family Law Reform Act. Age and competence of the patient come first.
Yeah.
Trap 2. Promise absolute secrecy forever.
I see why junior doctors might choose this, out of compassion, to build rapport.
Yeah, you want to help.
But you can't promise it. You have an overriding mandatory safeguarding duty. You have to explain the limits.
Trap 3. Refuse contraception unless the parent attends. If you've assessed them as Gillick competent and they meet the 5 Fraser criteria, refusing care just scores badly. The law allows you to provide that care.
Then there's trap 4. Apply adult MCA rules to under 16s. As we said, Gillick competence is a different framework. Confusing the two is a major error.
And what's one more?
Trap 5. Refer immediately to social services whenever a parent and child disagree. Disagreement is normal. Immediate referral is only for risk of significant harm, neglect, or abuse. Escalating to a senior is usually the right intermediate step.
That focus on proportionality seems to be what sets the high scorers apart. Let's finish with a rapid-fire review using that age-safe structure.
Let's do it.
A competent 16-year-old refuses life-saving care. Treat the refusal seriously. Confirm capacity, involve seniors, and seek urgent legal advice because of that residual court power.
An under 13 discloses sexual activity.
Always, immediately, a safeguarding referral. The age automatically triggers the duty. No hesitation.
A disagreement between 2 separated parents, both with PR, about a treatment plan.
Escalate to a senior colleague promptly and document the conflict. You'll need to verify the PR status, and if it can't be resolved, you might need legal advice.
Okay, let's consolidate everything. The 3 key takeaways you need to hold on to for these questions.
Number 1, always check the age first, then assess competence or capacity next. That sets your legal framework.
Okay.
Number 2, specifically use the Fraser 5 criteria for contraception and sexual health decisions in under 16s. That's your key to lawful care.
And the 3rd.
And number 3, encourage parental involvement, but never make it a barrier to care. And you must set clear, transparent confidentiality limits to protect your safeguarding duty.
So here's where it gets really interesting. We've taken this complex legal framework and distilled it into the 5 steps of the age-safe structure. This disciplined approach means you're showing legal reasoning, not just guessing. And that really is the definition of professionalism.
And that leads us to a final, provocative thought for you to consider. When you think about that competent 16-year-old refusing life-saving care, where the court can still override their choice based on best interests, just reflect on the ethical weight that puts on you, the doctor. The concept of best interests is what allows protection to ultimately override autonomy for minors, even when capacity seems confirmed. How do you, as a clinician, justify that boundary?
An incredibly challenging thought, and one you need to be ready to wrestle with. Thank you for joining us for this deep dive into youth consent and capacity. Make sure you use that age-safe structured approach in your revision.
Use age-safe to turn stress into structure and structure into scores. And if you want to dive deeper into these high-scoring frameworks for your exams, you should check out PassThemSRA.com.